Many people have some idea of what it means to sue someone or a company, and we generally know it's a bad thing to be sued for large amounts of money. However, sometimes it may be necessary to go to court to protect your rights. Some common situations where you might find yourself involved in a court case is if your employer wrongly terminates you from your job, if someone injures you in a car accident, or if someone damages your property. Generally speaking, when people go to court because of a conflict about money or property, this type of law is called civil litigation. Even though there may be situations where it's necessary to rely on Ontario's court system to protect your rights, there is a lot of mystery about how a lawsuit moves its way through the court system. In this video, you'll learn the basics of how civil lawsuits work in Ontario. Also, it's important to keep in mind that this video will not discuss the family court system in Ontario, which deals with divorce, support payments, and child custody. If you want to learn about the family court system, you can check out our video called How Does Divorce Work in Ontario? Before starting a lawsuit, it's important to understand some of the different levels of court in Ontario. For example, if a person wants to sue another person or corporation for $25,000 or less, then the case will go to Ontario's Small Claims Court. If the case involves more than $25,000, then the case must go through another court called the Superior Court of Justice. These two levels of court have vastly different processes and financial costs. In this video, we'll be talking about the process involved at the Superior Court of Justice. But if you want to learn more about how the Small Claims Court works, check out our video, How the Small Claim Court Works in Ontario. If you and your lawyer believe that you have a legitimate reason to start a court case against another person or corporation, then the first thing your lawyer will usually do is contact the person who you are thinking about suing. Your lawyer will typically write a letter and send it by registered mail to the other person. Often, the person who received the letter will respond with a letter from his or her own lawyer, or he or she may ignore the letter altogether. If you decide that the only reasonable way for you to protect your rights is by going to court, then there are some important legal steps that come next. But before we get into that, it's important to understand that the entire process in civil court is regulated, and there are many rules that must be followed. In fact, almost each and every step that happens in a civil case in Ontario is carefully regulated by a set of laws called the Rules of Civil Procedure. The rules use technical legal language that is confusing for most people, and it's best to obtain the services of a lawyer to ensure that your case is handled in a way that complies with the rules. So, what do the rules say about starting a lawsuit? In Ontario, lawsuits are started by filing a legal document in court. There are two types of court documents that can start a court case under the Rules of Civil Procedure. These two documents are called a Notice of Application and a Statement of Claim. A lawsuit that is started by filing a Notice of Application is simply called an application, and the lawsuit that is started by filing a Statement of Claim is called an action. Depending on your case, one of these documents will be more appropriate than the other. However, the vast majority of civil lawsuits in Ontario's Superior Court of Justice are started by filing a Statement of Claim. When your lawyer files your lawsuit in court, he or she first creates a court document in his or her law office, and then hires a professional called a process server. The process server picks up the document from your lawyer's office, and then delivers the document to the courthouse, where a clerk reviews whether the document has been completed correctly, charges a filing fee, and then stamps copies of the document. One copy stays with the court clerk, and then the process server gives copies to anyone who has been sued in the lawsuit. A person who starts a court action by filing a statement of claim is called a plaintiff, and the person who has been sued is called a defendant. After a defendant receives a stamped copy of the statement of claim, they then have 20 days to create their own court document called a statement of defense. Sometimes, the defendant will want to start his or her own lawsuit against the plaintiff. In those situations, the defendant will need to create another document called a statement of defense and counterclaim. After the defendant gives a copy of his or her defense to the plaintiff and files his or her defense in court, the plaintiff has an opportunity to create another document called a reply, just in case the plaintiff wants to tell the court anything about what the defendant said in his or her statement of defense. If the defendant also made a counterclaim, then the plaintiff will need to file a document called a reply and defense to counterclaim. On the other hand, if the defendant ignores the lawsuit, the plaintiff or the plaintiff's lawyer could ask the court to do something called note the defendant in default, which basically means the defendant would lose the right to defend himself or herself, and a judge could order the defendant to pay money to the plaintiff. The various court documents we have mentioned may seem a bit confusing, but all of these court documents have a fairly simple purpose. Essentially, these documents are designed to let the plaintiff and defendant tell their sides of the story to the court. So when a judge eventually reads all of these documents, he or she will have an idea of what the case is about. All of the documents we've talked about so far are called pleadings. When all of the appropriate pleadings are exchanged between the plaintiff and defendant, as well as filed in court, then that milestone in the court case is called the close of pleadings. This milestone marks the beginning of the next step in the process. After the close of pleadings, the lawyers will usually create something called a discovery plan, which is a document that helps the lawyers carry out the next steps in the process. To learn more about how a discovery plan works, you can pause this video and check out our other video, What is a Discovery Plan? However, for the purposes of this video, it's important just to keep in mind that the plaintiff and the defendant must gather any documents in their possession that could be relevant to the lawsuit. For example, if a contractor renovates a kitchen for a customer, and then decides to sue his or her customer for an unpaid renovation bill, then the contractor might want to give his or her lawyer a copy of the contract that the customer signed, pictures of the newly renovated kitchen, and any invoices that the contractor sent to the customer. Being able to prove your case with documents and evidence is very important in any civil lawsuit. After all of the relevant documents have been gathered, they will need to be organized into a specific type of court document, which is called an affidavit of documents. To learn more about how an affidavit of documents works, feel free to pause this video and check out our other video called What is an Affidavit of Documents? However, for the purposes of this video, we'll just say that plaintiffs and defendants must exchange affidavits of documents between each other to ensure that they are both aware of the evidence which will be used in the court case. After the affidavits of documents are exchanged, the next step in the process is called examination for discovery. Although that might sound like a confusing legal term, it is simply a process where the plaintiff and the defendant must answer questions under oath. The person asking the questions is the opposing lawyer. In other words, if you are the plaintiff, then the defendant's lawyer will be asking you questions, and if you are the defendant, then the plaintiff's lawyer will be asking you questions. Examination for discovery is typically a face-to-face meeting, and the conversation is recorded and transcribed by a professional called a court reporter. Examination for discovery can be a stressful experience, and there are lots of details to consider. It's best to prepare for the meeting with your lawyer and ensure that you are ready for questions that you might be asked. If you'd like to learn more about examination for discovery, you can pause this video and check out our other video, How does examination for discovery work in Ontario? After questioning has been completed, it's common for the lawyers to exchange additional evidence and documents between each other. Sometimes, this additional evidence is requested because it was not included in either the plaintiff's or the defendant's affidavit of documents. Lawyers use a term called undertakings to refer to these additional pieces of evidence. Throughout the civil litigation process, either the plaintiff or defendant may schedule something called a motion, where he or she will ask a judge to make a decision about a procedural issue. For example, the plaintiff or defendant may want to have some evidence excluded from the court case, or force the other side to surrender evidence that is being withheld. Your lawyer will know if and when to schedule a motion. The next step in the process is called mediation, and it is optional in most cities in Ontario, but it is mandatory in the City of Ottawa, the City of Toronto, and the County of Essex. Mediation is another type of meeting between the plaintiff, the defendant, their lawyers, and a professional called a mediator. Everything that is discussed during mediation is confidential, and the conversation is not recorded. The goal of mediation is to reduce financial costs and delays in court cases in Ontario, and facilitate the early and fair resolution of disputes. Many people involved in civil lawsuits find that mediation is a preferable solution to their conflicts, because it is less expensive than continuing the court process, and there is more control over the outcome of the mediation session. In other words, if plaintiffs and defendants can agree to resolve their dispute through mediation, then the case will need to go to trial, where a judge will make a decision about what will happen in the case, and the result may not be entirely satisfactory to either the plaintiff or the defendant. After the above steps are completed, either the plaintiff or the defendant can begin the process of scheduling a trial date by asking the court to put the case on the trial list. Within 90 days after the case is set down for trial, the court will instruct the plaintiff and the defendant to attend a meeting with the judge. That meeting is called a pretrial conference. Before the pretrial conference, the plaintiff and defendant must create documents with many different items required by the judge, and it's best to work closely with your lawyer to ensure that these documents are properly prepared. At the conference, the plaintiff, the defendant, and their lawyers explain their side of the case, and the judge tries to help them reach a solution to their dispute. In other words, the judge encourages them to achieve a settlement. The judge may inform the plaintiff and defendant how he or she would decide the case if he or she was the judge for the trial. However, a judge that conducts a pretrial conference cannot be the same judge that actually presides over the trial if the plaintiff and defendant decide to proceed to a trial. That being said, a person who attends a pretrial conference should give serious consideration to a judge's opinion about his or her court case. The next and final step in the process is the trial. Often, the plaintiff and defendant will decide to settle their dispute before the case goes to trial due to high legal fees and the risk of losing the trial. In Ontario, losing a trial means that you will most likely be responsible for paying the winner's legal fees, as well as your own lawyer's fees. During a trial, both witnesses testify under oath while the lawyers ask them questions. Depending on the issues in the case, sometimes an expert, such as a doctor, engineer, or other professional, may be required to testify. At the end of the trial, the judge will make a decision. If a party is not satisfied with the judge's decision, an appeal may be initiated in some circumstances. Now you have an idea of how civil actions work in Ontario. However, it's important to remember that this video simply describes some of the basics of civil litigation, and it is not intended as legal advice. You should always consult a lawyer if you have specific questions about your own unique situation.